Yes, sir. Good afternoon, sir.
Good afternoon.
Okay, sir, you are live.
Okay. A very good afternoon to all the viewers. Myself, Dr. Rajesh Singh, Associate Professor, Parul Institute of Law, Parul University. So today we have one big advocate from the Supreme Court, Dr. Professor Ramesh Gautam, who is the senior advocate from the Supreme Court of India. And according to the profile of Sir, Sir has been practicing since last 35 years. He has completed his LLB and LLM and LLD, that is the PhD in law, and has also been awarded honoris causa for 5 prestigious universities. He is a visiting professor in many universities in India and overseas. He has been an advocate general for the 7 states, and he is an endorser for the climate principle for enterprises. He has conducted several cases of international and national importance. His clients includes central ministers, governors, and the chief minister. He has been advised many foreign bankers, including KfW, Germany, Nordic Investment Bank, Finland, Swiss Bank Corporation, Barclays Bank, London, Lloyd Bank, etc., who has accepted his advice and grant a huge amount of loans to the government of India in 1994. Furthermore, he is the first Indian lawyer who has conducted international level dispute review boards, alternative dispute review cases for which he has entered in the Limca Book of Record. He is the third lawyer in the whole world to conduct ADR cases, and he has acted as an arbitrator and also as a counsel in many number of arbitration cases in India, as well as overseas. He is known personality in the field of law in India and abroad. He is a Padma Shri President of India awardee, Limca record holder, professor of law, author, writer, motivational speaker, political strategist, and analyst. He is also the senior arbitrator for several organizations. He is the global chairman and director general legal of International Human Rights Organization, world chairman legal and All India Council of Human Rights, Liberties and Social Justice chairman for Hindu Sanatan Vihani, and chairman and national legal advisor for ABMS, national legal advisor for Sri Purusharam International, fellow and senior members in Indian Council for Arbitrator and Bar Council of India. A recipient of 78 nation and international award, he is also hold the title of international jurist and the barrister in the instance of the Court of the London. He holds awards, many awards on this. So on this platform, I warm welcome you, sir. So today's topic of the webinar is a very important topic on the Constitution, which is the directive principle of state policy. So, sir, let me just tell you about our university, sir. We have around about 850 students which are seeing live of this particular webinar, sir. Sir, we have total 3 types of programs: BLLB, BCom LLB, and DBLLB. And sir, secondly, sir, we have around about 180 students in LLM program for around about 8 specializations, sir. So on this note, sir, we are not going to take more time. So on this note, sir, we are handing this session to you so that our student, and even though all we have circulated this for the High Court advocates, so they are also listening to you, sir. So on this note, sir, I am handing this session to you, sir. Over to you, sir.
Yeah, thank you very much, Dr. Rajesh, for such a warm welcome. And it is indeed a pleasure to be amongst you all. Though it is a virtual medium, let us straight away jump to the topic because we are already running a little late. First and foremost, it is important to understand the background of directive principle of state policy. The source of the concept of directive principle of state policy, DPSP, is the Spanish constitution, from which it came in the Irish constitution, and subsequently it was adopted by us for the Indian constitution. Articles 36 to 51 under part 4 of the Indian constitution deals with the directive principles of state policy. Article 37 of the Indian Constitution states that the application of directive principles of state policy These principles aim at ensuring socio-economic justice to the citizen of India and establishing India as a welfare state. Fundamental rights versus directive principle of state policy. Unlike the fundamental rights, the scope of directive principle of state policy is limitless, and it protects the rights of a citizen and work at a macro level. Directive principles of state policy comprises of all the ideals which the state should follow and keep in mind while formulating policies and enacting laws for the country. Directive principles are affirmative directions. On the other hand, fundamental rights are the negative or prohibitive in nature because they put limitations on the state. The directive principles of state policy are not enforceable by law. It is non-justiciable. It is important to note that the directive principles of state policy and fundamental rights go hand in hand, but in no way are the directive principles of state policies are subordinate to fundamental rights. The directive principles are classified on the basis of their ideological resource and objectives. These are directives based on, firstly, socialist principles, secondly, the Gandhian principles, and finally, on liberal and intellectual principles. Directive principles based on socialist principles. Article 38. The state shall strive to promote the welfare of the people by securing and protecting a social order by ensuring social, economic, and political justice, and by minimizing inequalities in income, status, facilities, and opportunities. Article 39. The state shall in particular direct its policies towards securing the following: right to an adequate means of livelihood to all citizens. The ownership and control of material resources shall be organized in a manner to serve the common good. The state shall avoid concentration of wealth in a few hands. Equal pay for equal work for both men and women. The protection of the strength and health of the workers. Childhood and youth shall not be exploited. Article 41, to secure the right to work, to education, to public assistance in cases of unemployment, old age, sickness, and disabilities. Article 42, the state shall make provisions for securing just and humane conditions of work for the maternity relief. Article 43, the state shall endeavor to secure to all workers a living wage and decent standard of life. 43A, the state shall take steps to secure the participations of workers in the management of industries. 47, to raise the level of nutrition and the standard of living of people and to improve public health. Directive based on Gandhian principles. Article 40, the state shall take steps to organize village panchayats as unit of self-government. Article 43, the state shall endeavor to promote cottage industries on an individual or corporative basis in rural areas. Article 43B, to promote voluntary formation, autonomous functions, democratic control, and professional management of cooperative societies. Article 46, the state shall promote educational and economic interest of weaker sections of people, particularly that of scheduled caste, scheduled tribe, and other weaker sections. Article 47, the state shall take steps to improve public health and prohibit consumption of intoxicating drinks and drugs that are injurious to health. Article 48, to prohibit the slaughter of cows, calves, and other milch and draught cattle and improve their breeds. Directive based on liberal intellectual principles. Article 44, the state shall endeavor to secure for the citizen a uniform civil code Uniform Civil Code through the Directive of India. Article 45, to promote early childhood care and education for all children until they complete the age of 6 years. Article 48, to organize agriculture and animal husbandry on modern and scientific lines. Article 48A, to protect and improve the environment and to safeguard the forests and wildlife of the country. Article 49, the state shall protect every monument or place of artistic or historical interest. Article 50, the state shall take steps to separate judiciary from the executive in the public services of the state. Article 51, it declares that to establish international peace and security of the state shall endeavor to do the following: maintain just and honorable relations with the nations, foster respect for international laws and treaty obligations, encourage settlement of international disputes by arbitration. Amendment in DPSP. 42nd Constitutional Amendment in 1976 introduced certain changes in Part 4 of the Constitution by adding new directives. Article 39, to provide free legal aid to the poor. Article 43A, participation of workers in the management of industries. Article 48A, to protect and improve the environment. 44 Constitutional Amendment in 1978 inserted Section 2 to Article 38, which declares that the state in particular shall strive to minimize economic inequalities in income and eliminate inequalities in status, facilities, and opportunities not amongst the individual but also amongst the groups. It also eliminated the right to property from the list of the fundamental rights. 86th Amendment of 2002 changed the subject matter of Article 45 and made elementary education as a fundamental right under Article 21A. Now let us discuss some associated case laws. Champakam Dorai Rajan versus State of Madras in 1951, the Supreme Court ruled that in case of any conflict between the fundamental rights and directive principles, the former would prevail. It declared that the directive principles have to conform to and run as subsidiary to the fundamental rights. It also held that the fundamental rights could be amended by the Parliament by enacting Constitutional Amendments Act. Golaknath versus State of Punjab 1967, which is one of the leading cases, the Supreme Court declared that the fundamental rights could not be amended by the Parliament even for implementation of directive principles. It was contrary to its own judgment in Shankari Prasad's case. Keshwanand Bharti, another leading case, one of the leading most case rather, Keshwanand Bharti versus State of Kerala in 1973. In this case, the Supreme Court overruled its Golaknath's case of 1967 and declared that the Parliament can amend any part of the Constitution but cannot alter the basic structure. Thus, the right to property, Article 31, was eliminated from the list of the fundamental rights. Then comes to the Minerva Mills case, Minerva Mill versus Union of India in 1980, in which the Supreme Court reiterated that the Parliament can amend any part of the Constitution, but it cannot change the basic structure of the Constitution. Implementation of DPSP, associated acts and amendments. Land Reforms Act. Almost all the states have passed the land reforms laws to bring changes in the society and to improve the conditions of the rural masses. These measures include abolition of intermediaries like jamidars, jagirdars, and inamdars, tenancy reforms like security of tenure, fair rents, etc., imposition of ceiling on land holding, distribution of surplus land among the landless laborers. Cooperative farming. Labor reforms. The following acts were enacted to protect the interest of the labor sections of the society. The Minimum Wages Act of 1948, Code on Wages 2020. The Contract Labor Regulation and Abolition Act 1970. The Child Prohibition and Regulation Act 1986, renamed as Child and Adolescent Labor Prohibition Regulation 1986. It was in 2016 that the name was changed. The Bonded Labor System Abolition Act 1976. The Mines and Minerals Development and Regulation Act 1957. The Maternity Benefit Act 1967 and the Equal Remuneration Act 1976 have been made to protect the interest of the women workers. Panchayat Raj system, through 73rd Amendment in the Constitution, which was brought in 1992, government fulfilled the constitutional obligation stated in Article 40. Three-tier Panchayat Raj system was introduced at the village, block, and district level in almost all parts of the country. Cottage industries. To promote cottage industries as per Article 43, the government has established several boards such as Village Industries Board, Khadi and Village Industries Commission, All India Handicraft Board, Silk Board, Coir Board, etc., which provide essential help to the cottage industries in finance and marketing. Education. The government has implemented provisions related to free and compulsory education as provided in Article 45, introduced by 86th Amendment in the Constitution and subsequently passed the Right to Education Act 2009. Elementary education has been accepted as fundamental rights of each child between the age of 6 to 14 years. Rural area development. Programs such as Community Development Program 1952, Integrated Rural Development Program 1978-79, and Mahatma Gandhi National Rural Employment Guarantee Act was launched to raise the standard of living, particularly in the rural areas, as stated in Article 47 of the Constitution. Health. Central government sponsored schemes like Pradhan Mantri Gram Swasthya Yojana and National Rural Health Mission are being implemented to fulfill the social sector responsibility of the Indian state. Environment. The Wildlife Protection Act 1972 and the Forest Conservation Act 1980 and the Environment Protection Act 1986 have been enacted to safeguard the wildlife and the forest respectively. The Water and Air Pollution Control Act have been provided for the establishment of the Central Pollution Control Board. Heritage preservation. The Ancient Historical Monument and Archaeological Sites and Remains Act has been enacted to protect the monuments, places, and objects of national importance. Thank you very much. Over to you. Dr. Rajesh, it is over to you.
Sir, it was very fantastic session, sir. We have certain questions on this particular topic, sir, from the students. Sir, as we have already, you have covered through the Sankri Prasad and Sajjan Singh, then you have also elaborated with Minerva Mills and all. Okay. Now, sir, now you have also elaborated about the child labor. Sir, is there a vision for the child that state can make the laws for the child, because state has various power, but which types of law which state can make for the child?
Hello.
Yes, sir. I'm
Yes,
audible.
can you repeat? Yeah, you were not audible. Now please tell me. Yes.
Sir, my question is that already state has empowered to make certain laws in the state for the welfare of the children also, correct?
Yes.
The question is, sir, that already like in education, we have Article 21A that state has to ensure that education should be provided free of cost from 6 to 14 years.
6 to 14 years.
In the case of labor, you know, if the childs are being, we have certain laws in our constitution for the prohibition of the child labor. Now, sir, question is that is there any laws which is made by the state for the protection of these type, because you know in the industries still the people are taking the children's and they are using for the packing industries and all. So
Yeah.
what is the solution for this, sir?
The states have also enacted certain laws, but even in the absence of the state laws, the Central Act will prevail. And child labor, of course, is prohibited under the central laws. States have also made certain laws and certain amendments, some additions and some deletions. But child labor is prohibited. In any case, child labor is not permitted at all. What
Yes,
is
sir.
being done is totally illegal.
Yes, sir.
Child
Yes, sir.
labor is not even allowed in the for the domestic works also. Even in the houses, no child below the age of 15 is allowed to work.
Yes, sir.
So
Very
what
true,
to
sir.
talk of industry? Industry is something which is much more serious.
So, sir, like you know, like we have gone through the Visakha case where there is a provision for the committee. So, is there any committee for the industries also
Yes,
for these child,
yes.
sir?
States have made committees for prohibition of child labor. States have appointed, labor officers, labor inspectors, assistant labor commissioner, and labor commissioners in the states, and they have to ensure that no child labor is being done. Child labor has to be prohibited in any case. It is a serious crime.
Yes, sir. Yes, sir. Sir, one more question, sir. That
Yes.
For the welfare of the women and children, there are special laws can be made by the state. Okay. So, sir,
Are
for
already there. Are already there.
yes, sir. So now for certain type of in the reservation when these special already we have gone through the Article 16 also, that there is a special provision for the reservation of these categories of the people. So what
Right.
state can do in this regard, sir?
There is already reservation. There is already reservation for children. There is already reservation for women. So that reservation, maybe you are talking about the implementation of that reservation.
Yes, sir.
Maybe,
Yes, sir. Yes, sir. Yes, sir.
maybe that implementation part is lacking, but there are already laws.
Okay, sir. Sir, we have these two questions from the student, and I think that my student have get more clarity on this particular topic. And
Yes.
sir, that sixth judgment you have quoted, that is very fantastic one, sir.
Yes.
So
These are all leading cases.
Leading cases,
which,
yes.
Which these law students will should study, and that will be very much beneficial for them in their practice also.
Yes, sir. Yes, sir.
Yeah.
So, sir, we are very much thankful to you, sir, on this note, and from the Parul Institute of Law, sir, that you have elaborated the speech's time, because as I know that you are the very topmost advocate from the Supreme Court, still you have
Thank you so much.
given time to us, sir. So we are very much thankful to you. And
no, any time for students, I'm always available.
Yes, sir. Yes,
prior,
sir. Yes, sir.
This thing, I'm always available for students.
Yes, sir. Yes,
this
sir.
profession of teaching I have adopted only as a voluntary cause, and I want to teach students. I want to give them knowledge, because these till 1976 judgment I have studied in my syllabus.
Yes, sir.
When I entered in practice, this 1980 judgment came.
Yes, sir. Yes, sir. Yes, sir. Yes, sir. True, sir. True. Yeah. So on this note, sir, we are very much thankful to you, sir. It was very fantastic session, and I know that your time is very precious, so we will not take more time. So on this note, sir, we are closing this session.
Yeah.
Thanks a lot, sir.
Thank you so much. Thank you so much.
Okay, sir.